Please be seated. The sitting is open. The court meets today to hear the oral observations of the 32 intervening states. Intervening states will address the court today following the alphabetical order in French. A period of 10 minutes has been reserved for each state that elected to make an individual oral observation, while states that elected to present joint oral observations will have 15 minutes for those observations. I now give the floor to Ms. Wiebke Ruckert for Germany. You have the floor, Madam.
Madam President, distinguished members of the Court, it is a great honor to address you on behalf of Germany and to commence the oral proceedings, the oral observations of states intervening in this important case. Ukraine initiated these proceedings on 26 February 2022, just 2 days after the Russian Federation invaded Ukraine on 24 February. In an attempt to justify its armed aggression, Russia had alleged that Ukraine was committing genocide on its territory, the alleged victims of this purported genocide being ethnic Russians living in the eastern part of Ukraine. As the Court is all too aware, the duty to prevent and to punish genocide is enshrined in Article 1 of the Genocide Convention. It constitutes, as the Court had occasion to confirm, a central obligation under international law and an essential feature of the Convention. As the other obligations under the Genocide Convention, it is an obligation of an erga omnes partes character that states owe not to one, but to all contracting parties of the said Convention. When relying upon the alleged genocide purportedly committed by Ukraine to justify its military action, Russia, in substance and in essence, referred to this erga omnes obligation. In an unprecedented move, 32 states parties of the Genocide Convention, more than 1 in 5 contracting parties, have asked to intervene in the current proceedings. This in itself shows that the parties to the Genocide Convention have a very strong interest in its proper interpretation in this case. Germany ratified the Genocide Convention as early as 1954. My country is particularly grateful to the Court for this opportunity to intervene according to Article 63 of the Statute of the Court, because Germany has a specific interest in upholding the integrity of the Genocide Convention, not least in view of our own past. Madam President, distinguished members of the Court, the question before the Court today is limited to the issue as to whether it has jurisdiction to hear this case. Germany strongly believes that it does. This question concerns the proper construction of the Convention's compromissory clause, that is, Article 9. Allow me to address 4 elements that, in our view, are essential for the interpretation of that article with regard to the case at hand. These elements individually, and even more so when considered together, unequivocally confirm that the Court does indeed have jurisdiction to hear Ukraine's case. First, the question as to whether a dispute exists under the Genocide Convention. There's no need for me to deal with the notion of dispute, as so consistently interpreted by the Court in its jurisprudence. It suffices to note that when the case was brought, Ukraine and Russia undoubtedly held diametrically opposing views as to whether or not Ukraine was responsible for acts of genocide on its territory. Let me also comment in passing that it is telling that once the case had been brought, and thus after it had already invaded Ukraine, the Russian Federation no longer relied on this justification after the critical date. But given the Court's jurisprudence, this is of no relevance. On the whole, there can be no doubt that there is a disagreement on a point of law and of fact, a conflict of legal views, and thus a dispute between the two parties. Let me also note that in the case of the Gambia versus Myanmar, the Court confirmed that it is not a prerequisite for seizing the court that a treaty or one or more of its provisions were explicitly referred to in a specific way prior to the seizing of the court. Rather, the existence of a dispute is a matter of substance, not a question of form or procedure. It is therefore Germany's considered view that a dispute in the sense of Article 9 of the Convention exists in the present case. Second, Germany is of the view that Article 9 of the Genocide Convention was intentionally formulated in a broad manner. This article gives the court jurisdiction not only over the interpretation and application of the Genocide Convention, but also over its fulfillment. In order to decide whether a state party has fulfilled its obligation under the Genocide Convention, the court must be able to declare whether or not acts of genocide have occurred. It thus logically follows from both the wording and the object and purpose of the provision that it provides the court with jurisdiction in cases where the question is whether or not genocidal acts have indeed been or are being committed by a state party. How could the court otherwise decide whether a state party is fulfilling its obligation not to commit genocide arising under the Convention? Third, Germany contends that Article 9 also applies to a situation in which one state party, in the case at hand the Russian Federation, relies on and refers to the Genocide Convention in order to justify another action which would otherwise be manifestly unlawful under international law. According to Article 9 of the Genocide Convention, and as confirmed by the court, states may bring disputes before the court, including those relating to the responsibility for genocide. Whether or not state responsibility of a state party of the Genocide Convention for alleged acts of genocide can be relied upon to justify another act constitutes a dispute that relates and is intrinsically linked to the responsibility for genocide. This is due to the fact that if a responsibility for acts of genocide had indeed been occurred, an erga omnes partes obligation under the Genocide Convention would have been violated. And that could in turn provide a justification for countermeasures under specific circumstances and within the limits of international law. A state party to the Genocide Convention, in the case at hand, the Russian Federation, may at the very least, however, not take actions which are otherwise unlawful merely based on abusive and wholly unsubstantiated allegations of genocide. Rather, the Genocide Convention contains a duty to employ all multilateral and peaceful means available to prevent genocide, in particular to bring the situation to the attention of the United Nations Security Council, as contemplated in Article 8 of the Convention. This reading of the Genocide Convention is further confirmed by its preamble, which emphasizes the need for international cooperation to liberate mankind from genocide. Consequently, a state party is violating its obligation to apply the Genocide Convention in good faith when it abusively alleges that another state party has committed acts of genocide and relies upon this allegation to justify an action which would otherwise be unlawful. Fourthly, in Germany's view, not only the state party that raises accusations of genocide is able to submit a dispute to the court. Rather, the state party accused of acts of genocide may do so as well. The wording of Article 9 makes this clear when it states that any of the state parties to a dispute may seize the court. A state party accused of acts of genocide, in particular, has a vested legal interest in obtaining a resolution of the dispute by the court. Otherwise, a state party that is being portrayed without even a hint of evidence as being involved in a genocidal campaign, or, as in the case at hand, is even invaded by a neighboring state on such a pretext, could not seek protection from the court despite the broad language of the Convention's compromissory clause. Madam President, distinguished members of the court, let me summarize Germany's interpretation of Article 9 in the case at hand as follows. Article 9 of the Genocide Convention confers on the Court jurisdiction to find whether an applicant state complied with the Convention where this is the object of disagreement and opposing legal views, and thus the object of a dispute between the parties to a case. Article 9 of the Genocide Convention also covers disputes in which one state party of the Convention alleges that another state party is committing acts of genocide, and where, relying on such accusations, the former state party then takes action in the form of using military force against the latter. In order to resolve such a dispute, the Court is, in Germany's considered view, called upon to apply the Genocide Convention to the relevant facts in order to determine whether there is a basis for such allegations. Madam President, distinguished members of the Court, this concludes Germany's observations in this case, which, let me reiterate, is of particular importance for Germany. Thank you for your kind attention.
I thank Ms. Ruckert, and I now give the floor to Mr. Stephen Donoghue for Australia. You have the floor, sir.
Madam President, distinguished members of the Court, it is a great honour to appear before you again on behalf of Australia. Australia's Prime Minister and Foreign Minister have strongly condemned the Russian Federation's invasion of Ukraine and share the Court's deep concern, as expressed in its Provisional Measures Order, about the continuing loss of life and human suffering taking place in Ukraine. Australia's intervention in this proceeding reflects and reaffirms its commitment to protecting and promoting the rules-based international order and to upholding the integrity of the Genocide Convention. Australia also intervenes in the spirit of assisting the Court in discharging its vital role in the peaceful settlement of international disputes as the principal judicial organ of the United Nations. Madam President, members of the Court, I will make two submissions. The first submission is that a dispute regarding the scope, content or exercise of obligations under Articles 1 and 4 of the Genocide Convention falls within Article 9. More specifically, a dispute as to the scope or content of those articles, by definition, relates to the interpretation of the Convention, while a dispute concerning the exercise of obligations arising or allegedly arising under those articles relates to the application or fulfilment of the Convention. In this case, for reasons I will briefly develop, Article 9 is engaged on both bases. As Australia understands it, the essence of Ukraine's case is that the Russian Federation has accused it of committing genocide in breach of the Convention and has then relied on its own obligation under Article 1 to prevent and punish genocide and its obligation under Article 4 to punish persons committing genocide as a pretext for taking harmful action in and against Ukraine. Ukraine, of course, denies that it has done anything that might constitute genocide, and the Russian Federation, on the other hand, now denies that it has relied on the Convention to take action in and against Ukraine. The resolution of those competing contentions I've just summarised is for the merits stage. The point of present importance is that the competing claims reveal a dispute about, at least, the application or fulfilment of Articles 1 and 4 of the Convention with respect to Ukraine's alleged conduct. That dispute is within the Court's jurisdiction under Article 9. A separate but related reason why Article 9 is engaged concerns Ukraine's arguments with respect to good faith and due diligence. As with any treaty, the rights and obligations set out in the Genocide Convention must be interpreted and performed in good faith. Contracting parties must therefore abstain from actions that frustrate the Convention's purpose or abuse its provisions, including actions that are taken or allegedly taken to prevent and punish genocide. Ukraine contends that state parties to the Convention must act in good faith and with due diligence, both in determining whether genocide is occurring and that they must also act in good faith in determining what measures of prevention or punishment are appropriate in response. both of those submissions go directly to the interpretation of Article 1. Their correctness is an issue properly within the jurisdiction of the court under Article 9. As to Ukraine's submission that the Russian Federation has breached those requirements, that submission concerns the application or fulfilment of Articles 1 and 4. It follows in our submission that both aspects of those contentions, being the existence of the good faith and due diligence obligations under Articles 1 and 4, and the assessment of the conduct of the Russian Federation against those obligations, fall within the court's jurisdiction under Article 9. Madam President, members of the court, that brings me to Australia's second submission, which is that a dispute concerning whether a unilateral use of force by a contracting party is compatible with the duty to prevent and punish genocide also falls within Article 9. Ukraine has submitted that Articles 1 and 4 both contain an implicit obligation to act within the limits of international law when preventing and punishing genocide. In response, the Russian Federation asserts that this argument would incorporate an indefinite number of rules of international law with the objective of unduly expanding the court's jurisdiction ratione materiae under Article 9. Russia asserts, and I quote, that the implicit obligation conjured up by Ukraine is independent from the obligations that actually exist under the Convention and whether a violation thereof has been committed. End of quote. In fact, however, at least to the extent that Ukraine's argument concerns the unilateral use of force, that argument has a clear connection to the extent of the obligations that actually exist under Articles 1 and 4. That connection was recognised by the court when it observed in its provisional measures order in this case that, quote, it is doubtful that the Convention, in light of its object and purpose, authorise a contracting party's unilateral use of force in the territory of another state for the purpose of preventing or punishing an alleged genocide. The Russian Federation has now not only accepted that statement, but has gone further, stating that its position is that the Convention does not provide such a legal basis. Thus, despite justifying its so-called special military operation on the basis of an alleged genocide, the Russian Federation has now belatedly accepted, at least in its submissions before this court, that state parties cannot unilaterally use force to prevent or punish genocide in the performance of their duties under Article 1 or 4 of the Convention. In those circumstances, whatever the interaction might be between Articles 1 and 4 of the Genocide Convention and other rules of international law, neither party now argues in their submissions before this court that Articles 1 or 4 themselves authorise the unilateral use of force to prevent or punish genocide. The court's jurisdiction under Article 9 extends to making a declaration to that effect, which would be a declaration concerning the scope of the undertaking under Articles 1 and 4. It follows in our submission that the court would also have jurisdiction to declare that the Russian Federation's so-called special military operation in Ukraine was not authorised by the Genocide Convention. That is a matter concerning the application of Articles 1 and 4, and thus falls within the scope of the court's jurisdiction under Article 9. Finally, as is clear from this court's jurisprudence, its jurisdiction under Article 9 is unaffected by the fact that the conduct of the Russian Federation may also engage rules of customary international law or treaty obligations outside the Genocide Convention. Madam President, members of the court, we respectfully invite the court to confirm the points of construction of Article 9 of the Genocide Convention that I have just addressed, and we otherwise refer the court to Australia's written observations in relation to the other issues that arise at this stage of the proceeding. I thank you for your attention. That concludes Australia's oral address.
I thank Mr. Donoghue. I now invite His Excellency Mr. Emil Rufer to address the court on behalf of Austria, Czechia, Liechtenstein, and Slovakia. You have the floor, sir.
Madam President, members of the court, it is a great honor and privilege to appear before the court on behalf of the governments of the Republic of Austria, the Czech Republic, the Principality of Liechtenstein, and the Slovak Republic. Our governments presented joint written observations in the current dispute between Ukraine and the Russian Federation. The Convention on the Prevention and Punishment of the Crime of Genocide is a universal treaty acknowledging the inherent importance of and granting protection to some of the basic values of the international community as a whole. Therefore, we have legal interest in and attach fundamental importance to its correct interpretation. As contracting parties to the Convention, we wish to present to the Court our views on the correct interpretation of relevant obligations under the Convention. In accordance with the Court's order, our observations solely concern the construction of Article 9 of the Convention, which is relevant for the determination of the Court's jurisdiction. We accept that, in accordance with Article 63, paragraph 2 of the Court's statute, we will be bound by the Court's construction of the Convention in this case. My task today is to address the salient elements of the interpretation of Article 9 of the Convention, which we regard as relevant in the present dispute. In the interest of time, I will focus my observations on the following 3 points. First, Article 9 of the Convention is a broad jurisdiction clause allowing the Court to decide on negative declarations establishing the non-violation of the Genocide Convention by an applicant state. Second, Article 9 also vests the Court with the jurisdiction to adjudicate upon disputes relating to a violation of the Convention through false or abusive allegation of genocide. And third, the Genocide Convention, including its Article 9, must be interpreted in the context of the obligations of state parties under the United Nations Charter. Madam President, members of the Court, with your permission, I would now like to turn to our first point, that Article 9 allows the Court to decide on negative declarations establishing the non-violation of the Genocide Convention by an applicant state. This means that the Court has jurisdiction over disputes concerning the request of an applicant state for a declaration that it had not violated the Genocide Convention. We would like to highlight that Article 9 expressly allows the Court to adjudicate upon disputes relating to all aspects of interpretation, application or fulfillment of the Genocide Convention, including disputes, and I quote, relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3 of the Convention, unquote. Thus, we submit that when a state is accused by another state of being responsible for committing genocide, it has the same right to initiate proceedings before the court, just as the state making such accusation. In both cases, the responsibility of a state for genocide, or the absence of such responsibility, is at stake and forms the subject matter of the dispute. This interpretation of Article 9 is confirmed by the Court's jurisprudence. The Court accepted jurisdiction in cases regarding claims of non-violation of conventional obligations, as referenced in our written observations, such as the dispute between France and the United States of America concerning rights of nationals of the United States of America in Morocco, or the dispute between Libya and the United Kingdom concerning the aerial incident at Lockerbie. Therefore, we submit that under Article 9, the Court is competent to adjudge and declare the absence of responsibility for genocide, that is, the non-violation of the Genocide Convention by an applicant state. The second point of our observations concern disputes about a violation of the Convention through false or abusive allegations of genocide. The customary rule reflected in Article 31 of the Vienna Convention on the Law of Treaties obliges states to interpret a treaty in good faith. As this court held in the Gabčíkovo-Naďmároš case, the principle of good faith, I quote, obliges the parties to apply a treaty in a reasonable way and in such a manner that its purpose can be realized, unquote. The principle of good faith constitutes the positive side of the prohibition of abuse of rights. As such, the principle of good faith prohibits an abusive interpretation and/or application of the treaty. We submit that the subject matter of the dispute under Article 9 may concern the good faith interpretation, application, or fulfillment of any right and obligation under the Convention, as well as the good faith performance of the Convention as a whole. For instance, in a situation where a contracting party accuses another party of committing genocide without any factual and legal foundations, and acts in contravention of international law for the alleged purpose of preventing such genocide, the contracting party fails to interpret, apply, or fulfill the Convention in good faith and thus violates the Convention. For these reasons, it is our position that Article 9 of the Convention covers disputes concerning false or abusive allegations of genocide made with the aim of justifying illegal unilateral acts and disregarding the principle of good faith interpretation and application of the Convention. Third, we would like to point to the requirement of a contextual interpretation of Article 9 of the Convention. Under the customary rule reflected in Article 31, paragraph 3, letter C of the Vienna Convention, the Genocide Convention, including its Article 9, has to be interpreted in the context of, I quote, any relevant rules of international law applicable in the relations between the parties, unquote. The Charter of the United Nations constitutes such relevant international law applicable between the contracting parties of the Convention. One of the fundamental principles of the Charter stipulates that states shall settle their international disputes by peaceful means in such a manner that international peace, security and justice are not endangered. In the words of the court in the Nicaragua case, this principle is complementary to the, I quote, principle prohibiting recourse to the threat or use of force in international relations, or the principle of non-intervention, unquote. Article 9 of the Convention reflects and specifies the principle of peaceful settlement of disputes for the purposes of the Convention. Any dispute among contracting parties concerning the interpretation, application or fulfillment of the Genocide Convention has to be settled peacefully in accordance with Article 9. Consequently, we submit that Article 9 of the Convention also covers disputes whether a contracting party violated the Convention by failing to interpret, apply or fulfill the Convention in accordance with its obligations regarding the peaceful settlement of disputes under the UN Charter. To conclude, we would like to emphasize that Article 9 of the Convention establishes a mandatory procedure for the peaceful settlement of disputes which aligns with the aims of the UN Charter and allows the effective fulfillment of the object and purpose of the Convention. We submit that Article 9, interpreted in good faith in accordance with the ordinary meaning of its terms in their context and in light of the object and purpose of the Convention, covers dispute regarding the non-violation of the Genocide Convention by an applicant state and disputes relating to a violation of the Convention through false or abusive allegations of genocide, as we described in our joint written observations and outlined in this presentation. Madam President, members of the Court, I thank you for your kind attention.
I thank His Excellency, Mr. Rufer, and I now invite Ms. Kirli Beski to address the Court on behalf of Belgium, Croatia, Denmark, Estonia, Finland, Ireland, Luxembourg, Romania, and Sweden. You have the floor, Madam.
Madam President, distinguished members of the Court, it is an honour to appear before you today as the agent of the Republic of Estonia on behalf of Belgium, Croatia, Denmark, Estonia, Finland, Ireland, Luxembourg, Romania, and Sweden in these proceedings. Our states have the greatest respect for the Court and for the system of international justice in which it exercises its functions. Our group will solely focus on upholding international law, notwithstanding political comments regarding some intervening states. We are dedicated to supporting the Court in its efforts to ensure the good administration of justice. We wish to present 4 observations on the construction of Article 9 of the Genocide Convention. The first observation we wish to make is that Article 9 is a broad jurisdictional clause. It confers on the Court's jurisdiction over disputes concerning the fulfilment by a contracting party of its obligations under the Genocide Convention. The inclusion of the term fulfilment in Article 9 is rare in the dispute resolution clause of a multilateral convention, which is usually limited to disputes concerning interpretation and application. The inclusion of the term gives the jurisdictional clause a coverage as exhaustive as possible, covering disputes regarding the performance of all obligations under the Convention. This interpretation reflects the intent and the drafters and finds support in the travaux préparatoires. In its preliminary objections, the Russian Federation maintains that the claims of Ukraine engage matters beyond the Genocide Convention and are therefore outside the Court's jurisdiction. However, it follows from the case law of the Court that certain facts or omissions may give rise to a dispute that falls within the ambit of more than one treaty. A parallel dispute arising out of the same facts, for instance about the use of force between 2 states, does not create an obstacle to the Court's jurisdiction under Article 9 of the Convention, if the conditions for the exercise of its jurisdiction are otherwise met. Therefore, a dispute relating to the interpretation, application, or fulfilment of the Genocide Convention falls within the Court's jurisdiction, irrespective of whether there exists, based on the same facts, a dispute between the parties concerning their rights and obligations under any other instrument. The case law of the Court shows that disputes concerning the Genocide Convention can be about non-action, i.e. about allegations that a contracting party is not honouring its obligations to prevent and punish genocide. The ordinary meaning of the terms of Article 9 also makes it clear that there is no need to establish that genocidal acts have been committed in order to engage the Court's jurisdiction. In our view, under Article 9 of the Court's jurisdiction goes beyond disputes about responsibility for alleged genocidal acts. It also covers disputes about the performance of any obligation imposed by the Convention, as well as whether allegations of genocidal acts are true or have been made in bad faith. Accordingly, we submit that the Court has jurisdiction over the question of whether genocidal acts have been or are being committed when there is a dispute about such a question between 2 or more contracting parties to the Genocide Convention. Madam President, let me now turn to our second observation on the construction of Article 9. As this Court has stated, it is difficult to imagine a convention with a greater humanitarian and civilizing purpose than the Genocide Convention. Article 1 of the Convention obliges contracting parties to prevent and punish genocide. The contracting parties must implement this obligation in good faith. The Court has noted in the nuclear test case that good faith is one of the basic principles governing the creation and performance of legal obligations. It held in Gabčíkovo Nagymaros that, quote, the principle of good faith obliges the parties to a treaty to apply it in a reasonable way and in such a manner that its purpose can be realized." Unquote. As such, the obligation to interpret and apply treaties in good faith safeguards against misuse of the Convention. Prior to taking any action in purported prevention of genocide, states must assess whether a genocide or serious risk of genocide exists. While acknowledging that Article 1 does not specify how to fulfill this obligation, the Court considered that states, quote, must implement this obligation in good faith, taking into account other parts of the Convention, in particular Articles 8 and 9, as well as its preamble, unquote. If a state purports to act to prevent a genocide that it has falsely alleged is taking place, such action is clearly unreasonable and contrary to the principle of good faith, as well as being manifestly abusive and incapable of conferring any legality on the conduct concerned. Contracting parties to the Genocide Convention have undertaken to prevent genocide for the benefit of humanity, not to protect their own interests. It would be a denial of the purely humanitarian and civilizing purpose of the Convention if it could be used to try to mask the wrongfulness of action taken in its name. In addition, the Convention's object to protect the most elementary principles of morality requires that a contracting party does not abuse its provisions for other purposes. Accordingly, the ordinary meaning of the terms of Article 9, read in the context of the Convention as a whole and in the light of its object and purpose, must include the jurisdiction of the Court to determine whether the making of false and abusive allegations of genocide by a contracting party has resulted in a violation by that party of its obligation to fulfil the Convention in good faith. Madam President, members of the Court, this concludes my presentation. Mr. Piet Herboth will now present our last two observations on Article 9. I thank you and the Court for your kind attention and ask that you invite Mr. Herboth to the podium.
I thank Ms. Vesky, and I now invite the second speaker for these 9 states, Mr. Piet Herboth, to address the Court. You have the floor, sir.
Madame la Présidente,
Madam President, distinguished members of the Court, it is a privilege for me to appear before the Court today as agent of the Kingdom of Belgium on behalf of our group of states. With the Court's permission, I shall now address our third observation. Article 9 of the Genocide Convention also applies to disputes concerning the lawfulness of actions taken for the stated purpose of preventing and punishing alleged genocide. As the Court has repeatedly stated, contracting parties, when fulfilling their duties under Article 1, must act within the limits permitted by international law. In that regard, states may only undertake acts which are in conformity with the United Nations Charter. Accordingly, a state cannot invoke its undertaking under Article 1 of the Convention as a justification for unlawful conduct, including the threat or use of force. The Genocide Convention provides guidance concerning the lawful means by which the contracting parties may prevent and punish genocide. The proper construction of Article 1 requires consideration of other parts of the Convention, including its preamble and Article 8, under which all parties may call upon the competent organs of the United Nations to take action, and Article 9, which provides for the judicial settlement of disputes. A dispute relating to the interpretation application or fulfillment of the Genocide Convention, within the meaning of Article 9, exists in all cases where two contracting parties hold opposing views on what the undertaking to prevent and punish genocide pursuant to Article 1 actually entails. Madam President, let me now turn to our fourth and indeed final observation. As established by my colleague, the concepts of dispute and fulfillment in Article 9 of the Convention are sufficiently broad to confer on the Court jurisdiction to declare that an applicant contracting party has not committed any breach of the Convention, as alleged by a respondent party. Moreover, the wording of Article 9 itself confirms that any of the parties to the dispute may seize the court. In any case, the erga omnes partes nature of the prohibition of genocide, which underpins the Convention, speaks against limited access to the judicial protection of the court. Any view to the contrary would risk preventing a party which is the victim of false and abusive allegations of genocide from seeking relief from the court in the face of abuse of the Convention by another party. This would undermine the Convention's credibility as a universal instrument for the prevention of genocide. It should be emphasized that the contracting parties to the Genocide Convention may invoke Article 9 and request a declaration from the court that it has not breached its obligations under the Convention. In the Lockerbie case, for instance, the court confirmed its jurisdiction over Libya's request for a declaration that it had not violated the 1971 Montreal Convention for the suppression of unlawful acts against the safety of civil aviation. Our construction of Article 9 is thus in line with the Court's jurisprudence. Madam President, our states have presented to the Court 4 observations on the construction of the Genocide Convention. This concludes our intervention, and we thank the Court for its kind attention.
Stramova for Bulgaria. You have the floor, madam.
Madam President, distinguished members of the Court, it's a privilege and honor to appear before you on behalf of the Republic of Bulgaria. On the 18th of November 2022, the Republic of Bulgaria submitted a declaration of intervention in the present case concerning the Convention on the Prevention and Punishment of the Crime of Genocide. Our foremost aim is to assist the Court in the interpretation of the construction in question of the Convention. As a contracting party to this treaty, Bulgaria has a fundamental interest to observe and contribute to the consistent interpretation, application, and fulfillment of the provisions of the Convention recognized as erga omnes norms in international law. With regard to the limits of the right of intervening state under Article 63, paragraph 2, as stated, in this statement, first, I intend to present Bulgaria's understanding of the proper interpretation of the compromissory clause of Article 9 of the Convention. They will address distinctive elements of the present case, referring to the rules and principles of customary international law as reflected in Article 31 of the Vienna Convention on the Law of the Treaties. Bulgaria concurs that Article 9 of the Convention is a broad jurisdictional clause vesting the Court with the proper power to adjudicate upon disputes about the interpretation, application, or fulfillment of the Convention by a positive or negative declaration. Respectively, the Court has jurisdiction to pronounce the existence or the absence of genocide, thus evaluating the allegations of one of the parties to that dispute that the other committed genocide. In addition, within the jurisdiction of the Court, pursuant to Article 9, falls the assessment of the conformity of acts based on false allegations of genocide within the provisions of the Convention. This competence of the Court includes evaluation of the lawfulness of actions taken for the purpose of preventing and punishing genocide that, if not performed in good faith, result in abus de droit. Now I would like to turn to the question of the general rule of interpretation of Article 31 of the Vienna Convention. There is no question about the relevance of interpretation in good faith in accordance with the ordinary meaning of the terms in the context of the treaty and in light of its object and purpose. Considering the time given, we would focus on paragraph 3, letter C of Article 31 of the Vienna Convention, stating that together with the context, any relevant rules of international law applicable in the relations between the parties shall be taken into account. As the International Law Commission stated, strategic integration governs all treaty interpretation and gives expression of the fact that treaties are a creation and conception of the international legal system. The Court observed in 1971 advisory opinion on Namibia that an international instrument has to be interpreted and applied within the framework of the entire legal system, thus giving consideration of the systemic integration provision in the process of evaluation of the case immediately after the interpretation of the primary intention of the parties by the conclusion of the treaty, as well as its object and purpose. Within the context of the use of force principle in the oil platforms case, the Court further stated that a treaty cannot be intended to operate wholly independently of the relevant rules of international law. Moreover, within the context of the Genocide Convention, this Court has stated that every state may only act within the limits permitted by international law. The doctrine claims the status of quasi-constitutional foundational norm of the strategic integration principle. It was once defined by Judge Bruno Sima as, I quote, a legally insurmountable limit to permissible treaty interpretation, end of quote. Mindful of this, Bulgaria submits that Article 9 of the Convention must be interpreted in a manner to define and guarantee the fundamental place of the Genocide Convention within the international legal system. In line with the peremptory nature of this instrument, its object and purpose as a reflection of the most elementary principle of morality, created in a reaction of the denial of the right of existence on the entire human group, and that genocide has inflicted great losses on humanity. The proper construction of Article 9 of the Convention should ensure the role of the Convention within the framework of the entire legal system. In conclusion, Madam President, distinguished members of the Court, the Republic of Bulgaria respectfully submits that the proper construction of Article 9 of the Genocide Convention confers jurisdiction on the Court to determine and declare that there is no violation of the Convention by the applicant. Furthermore, the failure to fulfill the Convention in good faith constitutes a violation of the Convention. In light of the above, today, it is of great importance that the decision of the esteemed Court upholds and defends the values of the Genocide Convention as it intended by its drafters 75 years ago and the parties thereto. Thank you for your attention.
Mr. Alan Kessel to address the Court on behalf of Canada and the Netherlands. You have the floor, sir.
Madam President, distinguished members of the Court, it is a great honour and a privilege for me to appear before this Court as the agent of Canada. Madam President, Canada and the Netherlands jointly appear before the Court today because of our shared interest in ensuring that the Convention at issue in the dispute between Ukraine and Russia, the Genocide Convention, is properly interpreted and applied. As contracting parties, we have a common interest in the accomplishment of the high purposes of this Convention. We therefore intervene in this case pursuant to Article 63 of the Statute of the Court to place our interpretation of the relevant provisions of the Genocide Convention before the Court. We do so in response to the gravity of the circumstances giving rise to this case and its implications on the obligations shared by all parties. Canada and the Netherlands recall the profound consequences of Russia's illegal invasion of Ukraine, which has resulted in immense human suffering. It is against this backdrop that we intervene as part of our commitment to the protection and promotion of the rules-based international order and the peaceful settlement of disputes in which this court plays a vital role. In this regard, we welcome the court's swift decision on Ukraine's request for provisional measures in March 2022, which clearly and unequivocally ordered Russia to immediately suspend its military operations in Ukraine. And since then, we have repeatedly called on Russia to comply with the court's legally binding order. Madam President, I'll now turn to Russia's preliminary objections. In our joint written observations filed in July 2023, we set out our views on the construction of Article 9 and other provisions of the Genocide Convention that are relevant for the determination of the court's jurisdiction in accordance with the court's order of June 5th, 2023. Similarly, our presentation today will be confined to observations on the construction of Article 9 of the Genocide Convention, focusing on the principles that guide the interpretation of Article 9 and on the scope of this provision as the basis of the court's jurisdiction. With respect to the principles that guide the interpretation of Article 9 of the Convention, I will focus on the following two elements. First, I will present the provisions of the Vienna Convention on the law of treaties that govern the interpretation of the Genocide Convention. And second, I will examine the object and purpose of the Genocide Convention. Madame la Présidente,
Madam President, as an international agreement, the Genocide Convention must be construed in light of Articles 31 and 32 of the Vienna Convention on the Law of Treaties. Article 31(1) of the Vienna Convention sets out as follows the basic rule governing the interpretation of treaties. A treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. The term context includes the text and the structure of a treaty as a whole, including its preamble and its annexes. Moreover, the principle of good faith obliges the parties to apply the treaty in a reasonable way and in such a manner that its purpose can be realized. Thus, when interpreting the Genocide Convention, the ordinary meaning of its terms shall be understood in the context of the Convention as a whole and in the light of its object and purpose.
Me to the object and purpose of the Genocide Convention, and as recognized by this court in its advisory opinion on reservations to the Genocide Convention, the object of this convention is to safeguard the very existence of certain human groups and confirm and endorse the most elementary principles of morality. The Genocide Convention was manifestly adopted for a purely humanitarian and civilizing purpose, and those high ideals which inspired the Convention provide, by virtue of the common will of the parties, the foundation and measure of all its provisions. The court further noted that it was the intention of the United Nations to condemn and punish genocide as a crime under international law, involving a denial of the right of existence of entire human groups, a denial which shocks the conscience of mankind and results in great losses to humanity, and which is contrary to moral laws and to the spirit and aims of the United Nations. Madam President, in our view, the object and purpose of the Genocide Convention support a broad interpretation of Article 9. A narrow interpretation of this provision, which relates to the peaceful settlement of disputes, would indeed undermine the Convention's humanitarian and civilizing purpose. This brings me to the second topic of our presentation, which is the scope of Article 9. And this provision reads as follows. Disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present Convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute. And while the scope of Article 9 will be expanded upon by the agent of the Netherlands, I wish to make two general observations. First, Article 9 of the Genocide Convention sets out the contracting parties' agreement on how to resolve disputes under the Convention peacefully, in accordance with their obligations under Article 2.3 and 33 of the UN Charter. Article 9 of the Genocide Convention must thus be interpreted and applied in a manner consistent with the provision's central objective of achieving the peaceful settlement of disputes under the Convention. And second, Article 9 of the Convention's articles attribute jurisdiction to the Court under Article 36(1) of the ICJ statute for disputes arising under and with respect to this Convention. It confers jurisdiction to the Court over disputes between the contracting parties relating to the interpretation, application, or fulfillment of the Convention. And there is nothing in Article 9 that limits the Court's jurisdiction to cases where it is an applicant state accusing a respondent state of breaching its obligations under the Genocide Convention. It can equally apply to situations where an applicant state disagrees with accusations of a respondent state with respect to breaches of obligations under the Convention. Madam President, this concludes my presentation, and I thank you for your attention, and may I invite my colleague, the agent of the Netherlands, Mr. René Lefebvre, to expand on the scope of Article 9 to conclude our observations. Thank you, Madam President.
I thank Mr. Kessel. I now invite the second speaker for Canada and the Netherlands, Mr. René Lefebvre, to address the Court. You have the floor, sir.
Thank you. Madam President, distinguished members of the Court, it is a great honor and privilege for me to appear before this Court as the agent of the Kingdom of the Netherlands. The agent of Canada has presented the guiding principles on the interpretation of Article 9 of the Genocide Convention and offered general remarks on the scope of this provision. In my presentation, I will not address the existence of a dispute between the parties in this case, but will highlight the following 3 points relating to the scope of Article 9. First, the term dispute must be interpreted consistently with the wide meaning given to that term in the case law of the Court. Second, disputes can be referred to the Court at the request of any of the parties. And third, the inclusion of the word fulfillment in Article 9 supports a broad interpretation of this provision. I will turn first to the proper interpretation of the term dispute, as included in Article 9 of the Genocide Convention. The Court made clear in application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia versus Myanmar, that the term dispute as used in Article 9 should be interpreted consistently with the wide meaning given to that term generally in international law. It is well established that a dispute exists when there is a disagreement on a point of law or fact, or a conflict of legal views or interests between parties, provided that they hold views which are opposed to each other. It is not necessary that a respondent state has expressly opposed the claims of the applicant state. Furthermore, one state's denial that a dispute has arisen is not determinative of whether a dispute exists. This court also recognized that, and I quote, certain acts or omissions may give rise to a dispute that falls within the ambit of more than one treaty, end of quote. The court can thus exercise its jurisdiction under Article 9 in relation to allegations of violations of the Genocide Convention, irrespective of whether the conduct in question breaches other rules of international law. Finally, I wish to emphasize that a dispute under the Genocide Convention may exist despite the absence of a specific reference to the Convention in public statements by the parties. This court has recognized that a dispute may exist if public statements, and I quote, refer to the subject matter of the treaty with sufficient clarity to enable the state against which a claim is made to identify that there is, or may be, a dispute with regard to that subject matter, end of quote. Madam President, I will now turn to our second point, which is that disputes can be referred to the court at the request of any of the parties, as expressly stated in Article 9 of the Genocide Convention. It is clear from the ordinary meaning of these words that any contracting party facing what it considers to be unfounded allegations of a breach of the Genocide Convention can, on its own accord, bring the matter before the court. This language underscores that a court's jurisdiction is not limited to situations where an applicant state claims that a respondent state is responsible for genocide. I will now turn to our third and final point on the scope of Article 9, which relates to the inclusion of the word fulfillment in that provision. In our view, this addition to the more common formulation often found in compromissory clauses supports a broad interpretation of Article 9. This provision clearly encompasses disputes about the scope and content of the provisions of the Genocide Convention and the contracting parties' actions in respect of their obligations thereunder, including the duty to prevent and punish genocide outlined in Article 1. If a contracting party accuses another contracting party of committing genocide and takes corresponding actions purporting to respond to the alleged genocide, the interpretation, application, or fulfillment of the Convention is clearly at stake. The inclusion of the word fulfillment in Article 9 supports the view that the court has jurisdiction to declare whether allegations of genocide made by one contracting party against another are justified under the Genocide Convention, and also to decide on the lawfulness of any measures taken to prevent and punish an alleged genocide. A broad interpretation of Article 9 is further supported by the context of this provision, in particular the use of the words including and relating to, which underscore the comprehensive nature of Article 9. Madam President, members of the Court, I now wish to make concluding observations on the scope of Article 9 of the Genocide Convention. As we have outlined in our presentation today, the ordinary meaning of this provision, taken together with its context and the object and purpose of the Genocide Convention, confirms that a dispute over allegations of genocide and measures taken to prevent and punish such purported genocide clearly relates to the interpretation, application, or fulfillment of the Convention, and therefore falls within the scope of Article 9. The provision grants jurisdiction to the court to rule on a contracting party's compliance with its obligations under the Genocide Convention, irrespective of whether it is the acts or omissions of the applicant state or the respondent state that are at issue, provided that this is a matter in dispute between the parties to the case. Madam President, members of the Court, this concludes the observations of Canada and the Netherlands on the construction of the provisions of the Genocide Convention that are relevant for the determination of the Court's jurisdiction. Thank you for your attention.
I thank Mr. Lefebvre. Before I invite the next speaker to take the floor, the Court will observe a coffee break of 10 minutes. The sitting is adjourned.
Andonios will then address the Court on the construction of Articles 9 and 1
Please be seated. The sitting is resumed. I shall now give the floor to Ms. Marianne Stavronidis for Cyprus. You have the floor, Madam.
Madam President, members of the Court, it is an honor to appear before you again on behalf of the Republic of Cyprus. Allow me first to offer some introductory remarks highlighting the importance of the interpretive question before the Court at this preliminary objection stage of the proceedings. Mr. Antonios Giannakopoulos will then address the Court on the construction of Articles 9 and 1 of the Genocide Convention. Cyprus has exercised its right to intervene in this case under Article 63 of the Statute of the Court for two reasons. First, Cyprus wishes to put forward its views on the interpretation of the compromissory clause of the Convention of a great importance, whose construction is evidently in question in the present stage of the proceedings. This is not only because of the steadfast devotion of Cyprus to the peaceful settlement of international disputes. It is also because, as these proceedings make clear, the construction of the compromise necessarily brings into the frame the interpretation of other provisions of the Convention and of relevant rules of international law. These provisions and rules are, to quote from the Court's order of 5 June 2023, relevant to determining jurisdiction ratione materiae in this case, and are thus in question in the preliminary objections stage. Second, Cyprus speaks on a matter that is existential for it. Being a small state, with its own experience as a victim of unlawful invasion and occupation, Cyprus heavily relies for its security on the international legal order, with the Charter of the United Nations at its core. It is thus crucial for Cyprus that provisions in treaties are not left to the own appraisal of any state party in order to justify the use of force against other states, but are properly construed by states and ultimately by this Court. The construction of Article 9 of the Convention will allow the Court to consider whether reliance on the Convention can ever serve as a lawful basis for recourse to armed force. The submissions on Cyprus focus solely on the construction of the Convention without assuming or discussing any purported facts. Cyprus has thus limited itself throughout the written and these oral proceedings to making observations on the construction of the Convention without taking a position on any other matter before the Court in this case. Madam President, I would now ask you to call Mr. Giannakopoulos to the podium. I thank the Court for its attention.
I thank Ms. Stavronidis, and I now invite the second speaker for Cyprus, Professor Antonios Donoghue, to address the Court. You have the floor, Professor.
Madam President, members of the Court, it is an honor to appear before you today on behalf of the Republic of Cyprus. Cyprus makes two submissions on the construction of Articles 9 and 1 of the Convention. First, the scope of Article 9 encompasses disputes over whether the Convention has been invoked and over whether facts that call the Convention into application have taken place. It has been set out in written argument, as well as in the oral proceedings thus far, that the compromissory clause of the Convention is expressed in broad terms. Cyprus did not revisit the arguments on the broad scope of Article 9 right now. I will rather use an example to approach the question of scope, referring explicitly to the terms of Article 9. Now, if one state party asserts that another state party is violating the Convention, and the two states disagree on this, the former state party can evidently bring a claim before the Court on the basis of Article 9. If this is accepted, then it must also be that the latter state party, that is, the one accused of violating the Convention and positively opposing this accusation, may avail itself of the very same right. A state party must be able to request the Court to determine that any accusations of violation of the Convention levelled against it are ill-founded. In other words, it must be afforded the opportunity to clear its name. Article 9 provides it exactly with that opportunity. The relevant dispute is thus clearly one that relates to the responsibility of a state for genocide. This must be so, especially when an allegation of genocide is relied upon to resort to armed force. In such cases, a state party cannot hide behind the vagueness of its claims relating to the invocation of the Convention or the reliance upon the Convention in order to avoid having its allegations tested before the Court. If the compromissory clause could not be invoked to bring such matters to the Court, its effectiveness would be severely curtailed. Second, Cyprus submits that Article 9 of the Convention encompasses disputes as to the proper scope of the obligations to prevent and punish genocide under Article 1. An allegation that genocide is taking place activates the obligations of states parties to the Convention to prevent and punish the crime of genocide in accordance with its Article 1. Cyprus submits that the action taken by a state party in purported performance of its obligations to prevent genocide must be able to be tested. And it must be tested against the requirements of the Convention regarding the obligation, and thus also the outer limits of the right of a state party to prevent genocide. To put it simply, much like in alleging genocide, when taking unilateral action to purportedly prevent it, a state party appraises its own legal position and acts at its own risk. This means that it may be challenged as to its own appraisal and the unilateral action that it chooses to take, and thus runs the risk of being found to have misinterpreted the Convention and to have misapplied it to the alleged facts. If one state party claims to be acting to prevent genocide and the other state party considers this action to be unlawful, then this is clearly a dispute relating to interpretation, application, or fulfillment of the Convention. The Court has subject matter jurisdiction over such a dispute under Article 9. which effectively brings to bear the risk assumed by the state party acting unilaterally. Now, what the obligation of prevention entails is crucial. In particular, the Court has already determined that in acting under Article 1, a state may only act within the limits permitted by international law, as we have heard many times over the last 3 days. In line with this finding, Cyprus submits that no action taken in response to either a real or a perceived breach of a treaty could ever lawfully involve the use of armed force in violation of Article 2, Paragraph 4 of the United Nations Charter. This is true also for determining the scope of the obligation to prevent genocide under Article 1 of the Convention. Madam President, this concludes the submission on behalf of the Republic of Cyprus. I would like to thank the Court for its attention.
I thank Professor Tsanakopoulos, and I now invite Professor Santiago Ripoll-Correa to address the Court on behalf of Spain. You have the floor, Professor.
Madam President, distinguished members of the Court, it is a great honor to appear before you as agent of the Kingdom of Spain. Spain, among other 31 states, submitted a declaration of intervention under Article 63, Paragraph 2 of the Statute of the International Court of Justice. As determined by the Court in Paragraph 69 of its Order on Admissibility of the Declarations of Intervention adopted in June 2023, the construction of Article 9 and of other provisions of the Genocide Convention concerning the Court's jurisdiction ratione materiae is in question at the present stage of the proceedings. Spain wishes to offer the Court its interpretation of Article 9, considering that its statement may be of help for the construction of this article, and aware that this intervention implies that Spain will be bound by the Court's decision. Distinguished members of the Court, Article 9 of the Convention on the Prevention and Punishment of the Crime of Genocide confers jurisdiction to the Court to hear any dispute concerning the interpretation, application, or fulfilment of any provision of the Convention. Whereas the terms interpretation and application are terms commonly included in many compromissory clauses, the term fulfilment is unique as compared with the compromissory clauses found in other multilateral treaties. Indeed, during the drafting process of the Genocide Convention, there was a debate on the inclusion or not of the term fulfilment, which ended with its retention in the text finally adopted. Consequently, Spain considered that the term fulfilment should be interpreted as an autonomous reference to one of the three categories of disputes between states parties that may be submitted to the Court under Article 9, that is, in a manner similar to disputes concerning the interpretation or application of the Convention. Let me, Madam President, elaborate on this idea in a little more detail. States party to the Genocide Convention assume some specific duties to prevent and prosecute the crime of genocide at the national level. They are obliged not only not to commit genocide, but also to take measures to prevent and punish the crime of genocide, including the enactment of relevant legislation and punishing the perpetrators. Additionally, based on the assessment that genocide is a crime under international law, the Convention also encourages states to fight against genocide at the international level. Indeed, as the Court has stated, The contracting parties to the Convention must prevent and punish any act of genocide independently of the context of war or of peace in which it takes place, and independently of the circumstances linked to the domestic or international nature of the conflict. Moreover, this obligation is not territorially limited by the Convention. In this sense, in its judgment of February 2007 on the application of the Genocide Convention, the Court has referred to the obligation to prevent genocide even by states distant from the place of the event. As Spain has argued in its written text, it follows that the adoption of all these measures to prevent and punish the crime of genocide, both at the national and international levels, and with a scope as broad as the one described above, all these measures should be included under the concept of fulfilment. Therefore, in Spain's view, the inclusion of the term fulfilment entitles states parties to the Genocide Convention to submit to the Court a dispute that relates to any measure or action taken by another state party, including any form of measure or action clearly contrary to Article 1 and to the object and purpose of the Convention. Madam President, this interpretation of the term fulfilment is, as Spain has demonstrated in its written observation, is consistent with the interpretation given to it in international human rights law, of which the Genocide Convention is one of its most prominent precedents, as the Court pointed out in 1951. It is clear, moreover, that in adopting measures to prevent genocide, a state must act in accordance with the principles of international law as formulated in the Charter of the United Nations and in General Assembly Resolution 2625, including the principles of good faith, prohibition of the use of force, and non-intervention in internal affairs. Thus, the adoption of preventive measures that exceed the limits permitted by international law can also constitute a violation of the obligation to prevent as stated by the Convention, especially if such measures involve an abuse of law or have been taken contrary to the principle of good faith. Distinguished members of the Court, according to the interpretation of Article 9, and in particular of the term fulfilment offered by Spain, it is possible for a state party to submit to the Court any dispute regarding measures, actions or omissions adopted by another state party supposed to prevent a situation qualified by the latter as genocide, but which nevertheless constitute measures, actions or omissions that turn to be contrary to the object and purpose of the Convention because of the manner in which they are carried out, or their lack of good faith, or because of their manifest abuse. Whether or not these acts or omissions are contrary to the object and purpose of the Convention, whether or not they are taken in bad faith, or whether or not the recourse to the Convention is abusive, is to be determined by the Court. Madam President, distinguished members of the Court, Spain considers that this interpretation of Article 9 is consistent with the ultimate objective of the Convention, which, as stated in its preamble, is none other than to liberate humanity from genocide, a crime under international law contrary to the spirit and aims of the United Nations and condemned by the civilized world. Spain thanks the Court for your attention.
I thank Professor Ripoll Correa, and I now give the floor to His Excellency Mr. François Allebrun, for France. You have the floor, Excellency.
Madam President, distinguished members of the Court, it's a great honor for me to represent as co-agent my country before the Court. Just like 31 other states parties to the 1948 Convention for the Prevention and Punishment of the Crime of Genocide, France deemed it necessary to avail itself of its right to intervene in this case on the basis of Article 63 of the Statute of the Court. And in this respect, France wishes to emphasize the efforts of close coordination made by all member states of the European Union participating in the current proceedings in order to facilitate the Court's work. Madam President, members of the Court, I will focus on 2 points. I will first indicate that the Court has the right to focus on different cases, a large variety of disputes related to the Convention. And secondly, I will come back to the relevance of general international law for the construction of the 1948 Convention, and more specifically Article 9. As to the question of the construction of Article 9, which arises at the jurisdiction stage, it allows you to determine which dispute categories are likely to be submitted to the Court. However, as many intervening states have already underscored, the wording of Article 9 is one of a kind. It includes many specificities which have the effect of broadening its scope compared to other compromissory clauses. In accordance with the rules of construction as codified in the 1969 Vienna Convention, the terms used in Article 9 of the Genocide Convention must be interpreted so as to determine its exact scope. And I will make two brief observations in this regard. First of all, the terms of Article 9 do not involve any restriction on the configuration of the dispute. The Court may be seized by any contracting party in order to establish a breach by the respondent of its international obligations, or, as the case may be, a non-violation by the applicant of its obligations. Secondly, the Court can hear disputes related not just to the interpretation application, but also to the fulfillment of the Genocide Convention. And my country's opinion is that this is an important indication that the scope covered by Article 9 of the Convention should not be interpreted too restrictively. I would now like to make some observations on the connection between the 1948 Convention and international law and the consequences of this connection when interpreting Article 9. And in this regard, France deems it necessary to react to some of the interpretations of Article 9 suggested in these proceedings. I will come back in particular to the hazardous parallel drawn between the present case and the immunities and criminal proceedings case a few years ago between Equatorial Guinea and France, and that led to a judgment on preliminary objections on 6th of June 2018. In that case, the applicant had offered a broad interpretation of Article 4 of the Palermo Convention against transnational organized crime in an attempt to artificially extend the scope of the consent given under this instrument. Article 4, paragraph 1 states that state parties shall carry out their obligations under this convention in a manner consistent with the principles of sovereign equality and territorial integrity of states, and that of non-intervention in the domestic affairs of other states. End of quotation. And the applicant had deduced the following from this article, and I quote, the customary international rules on immunities of states and state officials and on the immunity of state property from execution are incorporated into Article 4, and the Court did not admit such a reading, and on the contrary held that Article 4 only refers to general principles of international law, and that the rules of customary international law relating to immunities of states and their agents are not incorporated in Article 4. But we cannot rely on this case to support the interpretation, which is overly restrictive, of the 1948 Convention, because the legal issues are resolutely distinct, and in this regard I shall make two brief remarks. First, Article 4 of the Palermo Convention is a general clause at the beginning of this convention, whose purpose is to recall the principle of sovereignty and not to establish new obligations under the convention. On the other hand, Article 9 of the 1948 Convention is a compromissory clause unique to this convention and relates to the settlement of disputes on treaty obligations. We know that compromissory clauses have a very specific aim, which is to confer jurisdiction to a judicial organ. They are procedural provisions, not substantive provisions, which function by reference. That is to say, they do not in themselves determine which is the applicable law for the settlement of disputes regarding the Convention, but they refer to the rest of the Convention to determine that law. These clauses, they will have their own logic, which must be taken into account when interpreting them. Secondly, in the Immunities and Criminal Proceedings case, the court recalled that a provision of a convention could not be interpreted in a way that integrates rules that were completely foreign to that convention. In so doing, the court has never held that the abusive interpretation and fulfillment of one of the provisions of the convention for purposes manifestly contrary to its objects and principles would fall outside the scope of that convention. Paradoxically, such a solution would in fact remove the most serious disputes on manifestly abusive interpretation and fulfillment of the treaty from the scope covered by the compromissory clause. Again, in this case, the court has no way indicated that the dispute in the way in which the convention is to be fulfilled did not concern the application and interpretation of this convention. On the contrary, although that was not the subject matter of the present case, it accepted that, and I quote, any interpretation which might arise with regard to the interpretation and application of Article 4 of the Palermo Convention could relate only to the manner in which the states parties perform their obligation under the Convention. End of quote. In this case, it is indeed the obligations contained in the Convention that are at issue, and the dispute concerns the manner in which they are fulfilled. In this respect, as the Court explained, state parties may be expected to perform their treaty obligations in a certain way without the text actually providing for specific obligations. This is the case, for example, of the obligation to fulfill treaties in good faith. Admittedly, the 1948 Convention does not contain a provision as such expressly prohibiting it from being fulfilled unreasonably in relation to its object or purpose. However, this does not mean that a state is permitted to do so because fulfillment in good faith necessarily follows from any treaty obligation. In France's opinion, it follows that disputes resulting from abusive allegations of genocide or relating to abusive instrumentalization of the obligation to prevent and punish genocide fall within the scope of the provisions of the Genocide Convention and therefore fall within the scope of consent provided by Article 9. Madam President, members of the Court, thank you for your kind attention.
I thank His Excellency Mr. Alabrun, and I now invite Ms. Zonovia Chaido-Stavridis to address the Court.
I now give the floor
Madam President, distinguished members of the Court, it is a great honour and privilege for me to appear before this Court today on behalf of my country. It should be stressed that as a matter of principle, the Hellenic Republic attaches the utmost importance to the peaceful settlement of international disputes, in particular through the International Court of Justice. The Hellenic Republic, as a party to the Genocide Convention, a major treaty seeking to condemn and punish a crime which shocks the conscience of mankind, appears here today because of its interest in ensuring the Convention's proper interpretation and, by extension, application and fulfillment. Consistent with our declaration of intervention and our written observations, I will focus on what we believe to be the proper construction of Article 9 of the Genocide Convention, This construction converges with that put forward by other intervening EU member states. Our interpretation of Article 9 is based on Article 31 of the 1969 Vienna Convention on the Law of the Treaties, reflecting customary international law. In line with paragraph 1 of this article, I will show that the ordinary meaning of Article 9, read in its context and in the light of the object and purpose of the Convention, calls for its broad interpretation and brings within the scope of this Court's jurisdiction the widest possible range of disputes arising under the Convention. I will start with the ordinary meaning of Article 9. I will not dwell upon the notion of dispute. Suffice it to say that the Hellenic Republic concurs with the interpretation given by the Court, inter alia in the present case, in its order of 16 March 2022. Regarding the phrase relating to the interpretation, application or fulfillment of the present Convention, including those relating to the responsibility of a state for genocide, the Hellenic Republic contends that Article 9 allows the Court to adjudicate upon a dispute concerning the alleged fulfillment by a contracting party of its obligations under the Convention. For the purposes of this presentation, I will divide the text of this phrase in three parts. First part, the words relating to. Second part, the phrase interpretation, application or fulfillment of the present Convention. And third part, the phrase including those relating to the responsibility of a state for genocide. In the first part, the words relating to require only that the subject matter of the dispute concerns any alleged violations of the Convention. Hence, where, like in the present case, an application concerns the conformity of certain acts with the Convention, the Court can exercise its jurisdiction under Article 9, irrespective of the question whether or not the conduct in question simultaneously breaches other rules of international law and whether or not the Court has jurisdiction over those matters. In the second part, which reads interpretation, application or fulfillment of the present Convention, the addition of the word fulfillment to the more common formulation usually found in compromissory clauses confers an added breadth to the clause, as confirmed by the travaux préparatoires, and further supports the view that the Court has jurisdiction ratione materia to declare the absence of genocide when genocide is being alleged to take place. Furthermore, the words of the Convention make clear that the compromissory clause refers back to all the provisions of the Convention, its entire life, including breaches thereof. Thus, while there can be a dispute under Article 9 when one state alleges that another state has committed genocide, there can also be a dispute under the Court's jurisdiction over the question whether genocidal acts have not been committed. The third part, the phrase including those relating to responsibility of a state for genocide, further corroborates the comprehensive nature of Article 9 and its broader scope compared to a standard compromissory clause. Furthermore, the context of the words relating to in this phrase confirms that the Court's jurisdiction also covers disputes between states about the absence of genocide and about the performance of treaty obligations by one or more states parties. I will now discuss the last part of Article 9, namely the phrase at the request of any of the parties to the dispute. This phrase expressly provides for the jurisdiction of the Court at the request of either the state that has made the accusation or the state accused. Thus, where there is a dispute concerning whether a state has engaged in conduct contrary to the Convention, the state accused of such conduct has the same right to submit the dispute to the Court as a state that has made the accusation. Otherwise, a state party could freely invent violations of the Convention, allegedly committed by another state party, without the latter being able to have recourse to the Court. This would exclude from the Court's jurisdiction genocide-related disputes, leading potentially to serious misuses of the Convention. In addition, the absence in Article 9 of any of the usual procedural requirements, such as to first attempt negotiation or arbitration, corroborates the broad character of this article. Madam President, distinguished members of the Court, I will now turn to the object and purpose of the Convention, which, as eloquently described by this Court, further advocates for a wide interpretation of Article 9. I will not quote here the relevant excerpts of this Court's judgments. I should only stress that the erga omnes partes character underpinning the Convention is associated with a mission entrusted to the Court back in 1948 to enforce it in the interest of all states, and speaks against an interpretation which would preclude a state against which false allegations of genocide have been made from seeking relief from the Court in the face of abuses of the Convention. The Convention's object to protect the most elementary principles of morality also requires from the state party not to abuse its provisions to pursue other aims. The purpose of the Convention clearly allows a state party which believes that the authority of the Convention has been abused by another state party to turn to this Court. Otherwise, the raison d'etre of the Convention and its credibility as a universal instrument for the prevention of genocide would be defeated, and the role of the Court as critical avenue for redress would be undermined. Madam President, distinguished members of the Court, in conclusion, my country strongly believes that Article 9 encompasses any dispute relating to the interpretation, application or fulfilment of the Genocide Convention, including a dispute regarding acts carried out by one state party against another state party, based on abusive claims of genocide, resulting in the violation of a good faith performance of the Convention. I thank you for your attention.
I thank Ms. Stavridi. I now give the floor to Mr. Stefano Zannini for Italy. You have the floor, sir.
Madam President, distinguished members of the Court, it is an honor to address you as the agent of the Italian Republic. After my opening remarks, Professor Attila Tanzi will address few of the arguments advanced by Italy in its written pleadings, which pertain to the Court's jurisdiction ratione materie. Ever since becoming a party to the Genocide Convention in 1952, Italy has committed fully to its promotion in all relevant fora. Italy is therefore particularly pleased to seize the opportunity to assist this Court in the interpretation of the provisions which are disputed in the present case. The erga omnes nature of the core obligations of the Convention accounts for the general and indivisible interest of all contracting parties in their proper interpretation, application and fulfilment. Accordingly, Italy believes that when the interpretation of this kind of obligations is at stake and the Court is seized of the matter, the Court should exercise its jurisdiction to the fullest extent. In so doing, as the principal judicial organ of the United Nations, the Court can discharge its role of guardian of international legality in a domain where objectivity and third-party assessment are of the essence. Madam President, I thank you for your attention, and I kindly request that you invite Professor Tanzi to the podium.
I thank Professor Zannini. I now invite the second speaker for Italy, Professor Attila Tanzi, to address the Court. You have the floor, Professor.
Thank you, Madam President. Madam President, distinguished members of the Court, it is an honor to be appearing before you today and to do so on behalf of Italy in so highly important proceedings. In the interest of time, I shall confine myself to two issues of construction of the broad compromissory clause in Article 9, which bear on the Court's jurisdiction ratione materie. The first one concerns the peculiar nature of an aspect of the applicant's cause of action, which qualifies as a non-violation claim. The second pertains to the contour of the law which the Court has the power to interpret and apply to the facts in dispute. Madam President, as to the first point, the Court's jurisprudence shows that its jurisdiction encompasses disputes submitted by states requesting a finding of compliance
when compliance has been disputed by the defendant. The fact that in such cases the defendant had not challenged the admissibility of non-violation claims is irrelevant, since the court could have raised it motu proprio under the competence principle. This general proposition applies all the more to applications grounded in Article 9, whereby the jurisdiction of the court may be set in motion, and I quote, at the request of any of the parties to the dispute, unquote. This construction is corroborated by the interpretive principle of the effet utile, and it cannot be derogated from by a retrogressive interpretation of the travaux of the Convention. It is thus wrong to construe Article 9 as conferring jurisdiction exclusively over applications complaining of violations allegedly committed by the defendant. Madam President, members of the Court, the prohibition on genocide and its ancillary obligations of prevention and punishment reflect a peremptory norm of international law. Therefore, the applicant has a compelling interest in the ascertainment of a situation of non-violation of the Convention, as do each and all contracting parties, as well as the international community as a whole. Italy believes that it is considerations of this kind which account for the wide scope of the compromissory clause in Article 9. Madam President, members of the Court, as to my second point, I wish to stress that Italy finds that the material scope of application of the Convention covers precisely the kind of situations which are disputed in the instant case, and this fully conforms with the prima facie assertment of your Court. And nothing in the present incidental proceedings justifies reversing the authoritative statement by a former President of the Court, whereby, for the purposes of jurisdiction, the facts as alleged by the applicant are pro term to be accepted as true. Further ascertainment will be for the merits. Consequently, Article 9 confers jurisdiction on the Court to interpret and apply Articles 1 to 4 in relation to the disputed facts before you. Articles 1 and 4 provide for the obligation to prevent and punish acts of genocide, and this implies a fortiori an outright prohibition of genocidal conduct. This supports the contention that Article 9 confers jurisdiction on the Court over the defendant's allegations concerning the applicant's alleged breach of Articles 1 and 4, and all the more so over allegations of genocide tout court. By the same token, Article 9 also affords jurisdiction over the applicant's claim that the defendant's allegations amount to an abusive interpretation of Articles 1 and 4. If assessed, such an abusive interpretation would be plainly in contravention with the general principle of good faith in treaty interpretation under Article 31, paragraph 1 of the Vienna Convention on the Law of Treaties. And this would amount, at one and the same time, also to a breach of the very Articles 1 and 4. Madam President, Italy deems that Article 9 plainly confers jurisdiction also over the applicant's complaint concerning the defendant's act of aggression against it. The jurisdictional link between such complaint and the Convention is twofold. First, it derives from the argument that the ostensible breach of Article 1 by the applicant would preclude the wrongfulness of the defendant's aggression. Second, the defendant's act of aggression brings the interpretation of Article 4 into play in relation to the scope of the admissible measures against alleged breaches of the Convention. To that end, Article 4, which provides exclusively for criminal law measures against individuals, cannot be interpreted in isolation from the basic principles of the United Nations Charter, as confirmed by your court. In conclusion, Madam President, Italy finds that Article 9 empowers the court to interpret and apply Articles 1 to 4 to all the facts in dispute, and to do so in conformity with Article 31, paragraphs 1 and 3, letter C of the Vienna Convention, the Law of Treaties. Madam President, distinguished members of the Court, this concludes my speech, and I thank you for your attention.
I thank Professor Tanzi. I now invite Professor Martin Paparinskis to address the Court on behalf of Latvia. You have the floor, Professor.
Madam President, members of the Court, good afternoon. It is an honor for me to appear before you on behalf of the Republic of Latvia, in the first case in which Latvia has chosen to take part in the oral proceedings, either before the Court or its predecessor. I do so with gratitude to Latvia's agent, Ms. Kristīna Līce, for her exemplary leadership, and in the presence of Latvia's co-agent, Mr. Edgars Trumkalns. Latvia's intervention in this case reflects the importance that Latvia attributes to the integrity of the Convention on the Prevention and Punishment of the Crime of Genocide, and therefore its proper construction in this case. I will first make one general overarching point. Latvia considers that the conclusions on construction of Article 9 and of other provisions of the Genocide Convention concerning the court jurisdiction ratione materiae reached in the order of 16th of March 2022 on a prima facie basis and in terms of plausibility of rights claimed are, upon full and considered reflection, correct, and should also be adopted at the present stage of the proceedings. I will now proceed to three particular submissions on the construction on the Genocide Convention. I will first address the broad formulation of Article 9. In this respect, Latvia asked the Court to follow the construction adopted in paragraphs 168 and 169 of the judgment in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide between Bosnia and Herzegovina and Serbia and Montenegro. It would similarly go with the established judicial grain for Article 9 to cover disputes concerning what Russia calls reverse compliance complaints. That is not something alien to international law, as Russia suggested on Monday, but what the Court did in rights of nationals of the United States of America and Morocco, and questions of interpretation and application of the 1971 Montreal Convention arising from the aerial incident at Lockerbie. Russia's attempts to distinguish these judgments must fail, since it cannot be the case that the Court has thrice misapplied the well-established jurisprudence requiring it to go into the matter proprio motu to always be satisfied that it has jurisdiction. Nor is there anything in the hypotheticals that trouble Russia about such claims that could not be resolved by good administration of justice by the Court, including on time limits, as well as by the proper application of the general principle of res judicata. I turn now to Latvia's second submission, namely that Article 9 applies to disputes concerning the prohibition of abusive allegations of genocide. Latvia agrees that Article 1 does not specify the kinds of measures that a contracting party may take to fulfill the obligation to prevent and to punish the crime of genocide. However, Latvia's submission is that when interpreted in good faith, in the context of Articles 4, 6, 7, 8 and 9, and in the light of the object and purpose of the Genocide Convention, Article 1 does prohibit allegations of genocide that are abusive. Article 9 therefore encompasses disputes about abusive allegations of genocide, where a contracting party making them and acting upon them has neither pursued any of the means in the Genocide Convention, nor provided, in the words of the court, proof at a high level of certainty appropriate to the seriousness of the allegation. We say, in short, that we substantially agree with Professor Tuvenan. I will conclude with Latvia's third submission, namely that Article 9 applies to disputes under Articles 1 and 4 about whether a state has acted within the limits permitted by international law in preventing the commission of genocide. We say, again, that we substantially agree with Professor Tuvenan. This construction builds on the point made by the court that in discharging its duty to prevent genocide under Article 1 of the Genocide Convention, every state may only act within the limits permitted by international law. This also applies to the limits set by the applicable rules on the use of force. Latvia's submission is that Articles 1 and 4 preclude those means for prevention of genocide which are not in conformity with the spirit and aims of the United Nations highlighted in the first preamble recital of the Convention, in particular the Charter's first purpose of the suppression of acts of aggression. Further, Article 1 characterizes genocide as a crime under international law. Good faith construction of this ordinary meaning confirms impermissibility of aggression, called the supreme international crime by the International Military Tribunal just 2 years before the Convention's adoption, as a means for prevention of genocide. Professor Tuvenan must be right. The Convention, to quote him, ne peut pas être un outil permettant de justifier des crimes de droits de gens et la prolifération des fleurs les plus odieux. Latvia's submission is not undermined by judgments in cases concerning preliminary objections in oil platforms, immunities and criminal proceedings, and certain Iranian assets, which Russia invoked as authorities for rejecting rules outside the treaty for the purposes of interpretation. Reliance on oil platforms is a category error, since Article 1 of the Treaty of Amity imposed no obligation, but merely formulated a general aim. As for the latter two cases, the key point is that those rules were, in the words of the court, respectively unrelated to the stated object and purpose, and simply not germane to the concerns underlying the drafting of the treaties being interpreted. Specialized treaties on cooperation in economic and criminal matters, on the one hand, and the customary corpus on state immunity, on the other, may indeed inhabit distinct juridical spheres. The concerns, institutions, and teleology of the Genocide Convention and the rules on the use of force expressed in the United Nations Charter are, conversely, closely intertwined. Latvia's proposed construction would not, as Russia argued on Monday, incorporate in the Convention all obligations of states arising from other sources of international law, but only take into account in the process of interpretation the relevant rules mandated by the custom reflecting Article 31, paragraph 3c of the Vienna Convention on the Law of Treaties. To paraphrase the merits judgment in oil platforms, the court jurisdiction under Article 9 to interpret Articles 1 and 4 extends, where appropriate, to the determination of whether action alleged to be taken as a means for prevention and punishment of genocide was within the limits of international law, including law on the use of force. Madam President, members of the Court, this concludes the submissions of Latvia at the present stage of the proceedings. I thank you for your kind attention.
I thank Professor Paperinskis. Your statement brings to an end this morning's session. The Court will meet again this afternoon at 3 p.m. to hear the remainder of the oral observations of the intervening states. The sitting is adjourned.